be 5. People versus DeHousis, submitted. Barlotta versus A.O. Smith Water, appellant? Respondent? 5, 2, and 5. People versus Jimenez, appellant? 5 and 1. Respondent? 5, 1, and 5. Pinckney versus New York City Health and Hospitals, appellant? 4 and 1 and 5. Lynx Capital Partners versus Bays Capital, appellant?
The appellant, 5 and 1, please.
Respondent? 5, 1, and 5. Chalking Capital versus Omanoff, appellant?
7 and 1, please, Your Honor.
Respondent?
8 minutes, Your Honor.
I'll give you 7, 1, and 7. People versus Divine Fredericks? Respondent? 5, 2, and 6. Upfront Megatainment versus Time is submitted. Samaritan Compass versus 1293 is submitted. And Davis versus Blev Realty is submitted. We'll start with People versus Boynton.
Good afternoon, Your Honors. Robin Richardson with the Legal Aid Society on behalf of Mr. Boynton. I am so happy to see the court back to normal. I'm not here to sit in the well today. I'm here because there was no affirmative showing that Mr. Boynton waived his constitutional rights. No,
Let's go right to the relief you're requesting, because I know he's already out at liberty. How are you entitled to the relief you're requesting? Wouldn't the normal relief just be the affirmance of the conviction or vacature of the plea?
Yes, Your Honor, but Burwell relief is also available in cases like this where there's a defective plea, where the sentence is already completed, and where we're dealing with a relatively minor offense.
Why should there be anything other, if you're correct, and let's assume you are correct, why should it be anything other than vacature of the plea?
Because we're dealing with a situation here where Mr. Boynton had a taser, not a firearm. He didn't brandish, threaten anybody. He didn't harm anyone. This is a situation where during a traffic stop, the officer asked him if he had
So
an...
your position is that we have discretion to do what we wish with it?
Yes, Your Honor, you do have discretion. You also have discretion to offer the alternative remedy that I asked for, which is the reduction of his conviction to criminal possession of a weapon in the 4th degree. That seems obviously pretty available under the criminal procedure law, which allows you to modify judgments. You've also done that, I think, as recently as 2022 in Perez, where you modified a conviction from assault 2 to assault 3 over the prosecutor's objections. So the remedies requested are available. It is
The
discretionary.
only thing wrong here, though, is the way that the plea was given. Why should there be any other remedy in this case?
Excuse me?
If the only thing incorrect here was the way that the plea was taken, why should there be any other remedy in this case?
Well, I think the reason why Burwell relief is often granted is just judicial, just to not have people back in clogging up the courts when there's a relatively minor offense and when the sentence is completed. It's just administratability, I believe. As for the merits of the case, we're lacking an affirmative showing here. This is a case, of course, where there's no issues, the court issued no warnings, and there's also nothing in the record which shows that he might have had some affirmative, no affirmative showing in the record, like indication that he spoke with his attorney about the plea, about the consequences of the plea, or any of the other situations that you've seen in other cases where there is an affirmative showing it absent those warnings. If there's no further questions, I will save the rest from a rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Peter Rienzi for the people. The relief defendant seeks as Your Honor's questions indicated, is inappropriate, that relief being dismissal or reduction only, and requesting affirmance if those are not granted. This court should affirm on that basis alone.
Why?
I'm sorry?
Why?
Well, it's not appropriate, Your Honor, because even if this court were to find the defendant's plea deficient, the remedy, as Your Honor pointed out, would be vacator and remand. This offense is not relatively minor. The people do not agree to dismissal. In addition, after his conviction on this case, the defendant currently is a predicate felon, so there would be a penological purpose to remanding it for further proceedings. Reduction to a misdemeanor is also not an appropriate remedy. The cases cited by defendant's brief all are very distinguishable from this case. Some of them, one case that was referenced involved a repleader, a question of whether or not the repleader should be granted. Nothing like that is the case here. At the time of defendant's plea, Judge Dwyer asked the defense if the allocution...
What should happen if the defendant is not entitled to the relief he seeks, but the plea was not correctly entered?
I'm sorry, Your Honor, you're asking me what would be the proper relief, or...
What's the proper decision for this court?
If the plea is found deficient?
He seeks dismissal of the indictment. If that's not the appropriate remedy, and if the remedy he seeks is inappropriate, but the plea was not properly entered, what should the court's response to that be?
If the court were to find that the plea is deficient, Your Honor, we would submit that the proper remedy would be that the defendant could get his plea and sentence back, and the case could be remanded to Supreme Court.
But he's not asking for that.
Well, Your Honor, I would submit that for that reason, the case should be affirmed. There are several cases where this court has done so in the last few years. Those are cited in our brief.
He sort of waives his right to vacatur of the plea by not requesting that relief. And
That is our position, Your Honor, yes. In addition, Your Honors, the plea, the authority is clear that a plea is not invalid solely because the trial court fails to recite particular rights under Boykin. There is no uniform mandatory catechism, as has been stated many times. This case compares favorably.
Here, the court failed to inquire with regard or provide any notice of any of the Boykin rights, correct?
That is correct, Your Honor. There is no record of that. Nonetheless, though, the plea and the record in this case compares favorably, or at least appears on par with several pleas that have been upheld both by the Court of Appeals and this court. Some of the factors noted by the Court of Appeals in Consacao include that the defendant was represented by counsel, and the record here implies that the defendant consulted with counsel and that counsel negotiated with the people for the disposition. The defendant told Judge Dwyer that he was satisfied with counsel's representation. This was a very rational plea bargain from the defendant's perspective. This was his 9th criminal conviction, and he received a minimum probation sentence. And in addition, as cited in the brief at more length, this claim was not preserved. The Court of Appeals, again, in Consacao, made clear that Boykin claims challenges to plea allocutions must be preserved, and that was not the case here. There are exceptions when the defendant has no opportunity to file a motion, but that was not the case here either, being that the defendant was sentenced 6 weeks after and no motion to withdraw was done.
Thank you.
Thank you, Your Honor.
I'll quickly correct something for the record. This was not a plea negotiated with the people. This was a plea offered by the court. And then regarding Consacao and the various factors listed there, there are 2 companion cases within that case, Perez and Sanchez, where no warnings were issued, but it was still found that there was an affirmative showing that the defendant knowingly, intelligently waived their rights. In Perez, what happened was that the defendant affirmatively stated that he had time to discuss the plea with his attorney. That did not happen in this case. And in Sanchez, there was an affirmative showing that the defendant knew the rights attending trial because he was actually supposed to go to trial that day. None of those facts exist here. And in every single case where there's no affirmative showing, where there's no affirmative showing, and even if there's no preservation, the court has reached that issue in the interest of justice, which is what I had asked this court to do here. Thank you.
Thank you. Cavito versus Flushing Commons.
Good afternoon. May it please the court. Jonathan Schaub for the defendant's appellants. The Supreme Court erred in granting summary judgment in this case because it mistakenly held that a violation of the Industrial Code automatically triggers liability under Labor Law 241-6. Under this court's precedent and the Court of Appeals precedent, that is incorrect. Instead, a violation of the Industrial Code is merely some evidence of negligence, and it remains plaintiff's burden to prove that there was a failure to exercise reasonable care. The plaintiff failed to carry his burden in this case because there are disputed issues of fact as to constructive notice and when the strap that plaintiff tripped on purportedly appeared on the floor. So this accident, on the day of the accident, plaintiff traveled down to the 13th floor and observed his work area. He noticed that there was debris on the floor, promptly went up to the 14th floor and requested that a Tishman laborer clear the area. Plaintiff then went and collected the supplies he needed to perform his work, and 35 to 40 minutes later, he appeared back at the job site and he inspected the area and he testified, "The quarter where I have to work was clean for me."
But that wasn't, the accident did not happen where he was working. It happened all the way down the hall when he was going to get supplies.
It happened in that hallway, but he testified.
That's not the area that he was working.
The corridor, which is what they had argued, he said it seemed clean, and the corridor where I have to work was clean for me. So that was what his testimony was. But then there's an issue, as there's a 2-hour window now. The area has been cleaned, so that's an issue of fact as to whether that strap was on the ground sufficiently long for there to be constructive notice.
Is there any evidence in the record at all how long that strap was on the floor?
There's no evidence. Plaintiff never saw it. So again, that would be an issue. Plaintiff was granted summary judgment, so that would be something he had to prove to carry his prima facie burden.
It could have been there for 5 minutes. It could have been there for days. No one really knows.
Exactly. And again, that would be something that was plaintiff's burden and would be an issue of fact for a fact finder to determine. But on this appeal, in the briefs, there's also been an argument suggested that that plaintiff said at pages 25 through 26 of their brief that what their real negligence claim on this 241-6 is that the laborer failed to clean the strap. The problem is that presupposes, as Your Honor was just suggesting, that the strap was there at the time that the laborer was performing the cleaning. But that is a disputed issue of fact, again, given the fact that it was cleaned and given the plaintiff's testimony.
Who else was working in this area
So the other people working,
other than the plaintiff?
there was Component, which was the carpenter on the project, and
But didn't Component say that they had not worked on the 13th floor on that day?
there's testimony from Component's a Component employee or supervisor who is in charge of safety that they were working there that day, and the straps that were found were actually used to bundle the wood that they were using to frame out their work. So that is where this could have come from at the time, and it could have happened after the cleaning was done, after the cleaning was performed, or it could have, that would be a disputed issue of fact as to when exactly it occurred.
Was Component the flooring contractor, or were they just doing sheetrock?
They were the general contractor, and Zapata, who was plaintiff's employer, was the sheetrocking subcontractor on this project.
The area where the strap was found, was that an area where the Tishman laborer would have or did clean pursuant to the plaintiff's complaint?
I believe that was an area where Tishman's worker did clean, or where he was clean. But again, the testimony is that when plaintiff went down, he noticed this area was not clean, requested it be cleaned, and then had the Tishman laborer did clean it. And then when plaintiff came back down, it was his testimony that he looked at the area, and we know based on what he did that day, if he had concerns about whether the area was clean or not, he would have gone back up and gotten someone to clean it. He also incidentally never saw the strap until the moment that he tripped. So again, there's all these questions of fact as to when this appeared, if it appeared at the time, if it was there before or during the cleaning or after the cleaning. And again, all we're asking for is for a jury to make this determination and not to have what happened here, where the Supreme Court seems to have said, because the plaintiff fell and because he said he tripped and because there was an alleged industrial code violation, that means that there's 241(6) liability. That's not this court's test, and that was determined as recently. This court, as May 11th, has held that, again, a violation of the industrial code is merely some evidence of negligence, but this is not a per se liability statute, and to treat it otherwise basically turns the 241(6) claim into a 240(1) claim. And unless the court has any further questions, I'll address any other issues on reply.
Thank you.
Good afternoon. Michael Taub from the Plata Law Firm. We represent the respondent. May it please the court.
What's incorrect about what opposing counsel said, that 241(6) does require negligence and that there are issues of fact with respect to how long the strap was on the floor in this case?
There is case law from this department, Your Honor, which does not say that. There was a case which I will
That
acknowledge.
says you don't require negligence for a 241(6) claim?
Yes, there is a case which this court decided, which is not in my brief. I've already given that case a citation to the clerk, to Mr. Dyckman, and to counsel as well, called Romano versus the New York City Transit Authority. If the court wishes a citation, it's at 213 AD 3rd, 506, which this court decided on February 14, 2003, a panel on which Justice Kern participated. Plain and simple, the court indicated that there was a violation of 241, a violation of the industrial code. In that case, it was 23-1.7E2.
Well, I'm looking at this, and I was on that panel, but it doesn't really discuss whether there was any issues of fact as to negligence. It says, requires that the floors of the work area be kept free, and it says this violation proximately caused plaintiff's accident. So we don't say, just from reading it, that negligence is not required. It just appears that there was not a disputed issue of fact in that case about the negligence.
The court did not address it, Your Honor. I am not familiar with the record
It doesn't cast light on the issue we face here.
Right, it doesn't say that negligence is not required. It's just not an issue that's being discussed in that matter, whether negligence is or is not required. So I don't know how it can stand for the principle that negligence is not required.
I can only represent to the court what's on the actual decision, that negligence was not indicated in that decision. I'm just reading the plain language of what the decision says. I think that answers Justice Kern's question, but to move on, if that's all right, Your Honor, to comment on what Justice Kern and Justice Rodriguez had said during my adversary's argument, it is not on the record where Tishman cleaned. So yes, Mr. Cavito said, well, after he asked the Tishman representative to clean, and when he came back some time later, yes, he said, well, it looks clear to me, or perhaps he said, well, it looks clean to me. But that doesn't mean that there was nothing there. There's no indication that Mr. Cavito had done an inspection. There's no indication that he had looked to see. He said, well, it seemed clear to me. There was no further questioning at the deposition as to what Mr. Cavito was basing that assessment on. As far as the 200 case goes from counsel, which is also in our brief, there was no evidence of any inspection done, which is a requirement for a defendant to obtain summary judgment on any fall-down case. There was no indication of that at all. And to comment on what was written in my adversary's reply, the fact that Mr. Cavito said, yes, it seems clear to me, is not part of their prima facie proof. They still have to show that there was an inspection done, and there was nothing in their brief about that. So at the very least, 200, the motion for summary judgment that my adversary made on 200, that appellant made on 200, would have to be denied. The motion for summary judgment that plaintiff made should be affirmed, and the motion for summary judgment on 241-6 that defendant made should be denied, so affirmed on appeal. At the
So if
very,
there's an issue of fact, this is a 241-6, there would definitely be an issue of fact as to the 200, because the issue of fact has to do with the negligence.
I understand that that was in our adversary's brief. It's not necessarily so. The fact that there was a violation of 241-6 on the part of Tishman can be attributed to the owner. They happen to be represented by the same defendant, but it was never mentioned in anyone's brief that Flushing Commons was responsible for Tishman's negligence as the owner to the general contractor.
Okay, thank you.
Thank you, Your Honors.
Just a few points very briefly. On the Romano issue, Justice Kern, I think you hit the nail on the head. Negligence is a requirement under the statute. That's Rizzuto, and that's this case court's decision in Leonard back on May 11th that says it's not enough to just show an industrial code violation. On the testimony of Mr. Quevedo, it was plaintiff who moved for summary judgment. It was plaintiff who obtained summary judgment, and he seems to be pointing to holes in the proof. These are issues of fact for the jury as to what was done and what was not done. On the inspection issue,
You're also appealing your denial of summary judgment.
on the 200, and again, we would say that given Mr. Quevedo's testimony, the quarter where I have to work was clean for me. It seemed clean, would carry that burden. Now, what plaintiff has seemed to have done is said because he tripped and fell, there must have been negligence. It's not what the statute requires.
But I mean, if the debris was there and he didn't notice it, that could still raise an issue of fact as to whether the debris was there, whether or not he noticed or didn't notice it.
And if there's an issue of fact, then there's an issue of fact, as you said, on the 241-6 and the 200. On the inspection issue, whether there was an inspection or not, it was cleaned. It was cleaned by Tishman before. And then, as I think you heard my adversary say,
Again, also, as I said at the beginning, the accident didn't happen where he was working. The accident happened down the hall.
but
where he
again,
was working.
the
So
testimony.
even if he said it was clean where he was working, he fell when he was going to get materials, which was not in his immediate work area.
But again, when he saw an issue or was concerned with an issue of debris, he was capable of going and asking for help. And then what I think you've heard my adversary say, which kind of addresses this point, is that the claim now is really focused on Tishman's negligence. And if that's the case, then there is absolutely a notice requirement and a constructive notice requirement for all of these claims. And there are disputed issues of fact as to how long the strap was there. No one can point to how long it was there for. And the testimony, the only testimony on the issue is it wasn't there when he started his work. So based on that testimony, there's at a minimum an issue of fact on this. And unless the court has any further questions, we rest on our briefs. Thank you very much.
Thank you. Scientific Games versus Mohawk Gaming.
Good afternoon, Your Honors. Brittany Suganik on behalf of the petitioners, appellants, Scientific Games Corporation, and SG Gaming, Inc. May it please the court. Let me start by acknowledging that we are very aware of the standard that applies to the petition we are seeking. So we understand how difficult it is to set aside an arbitrator's award. We nonetheless believe that
You concede that manifest disregard of the law is the standard.
I'm
There's
sorry.
no dispute as to what the legal standard is that we're applying in terms of our review, that it's manifest disregard.
That's right. The legal standard is manifest disregard of the law, and this is where we believe that
So how did the arbitrator, which issued a fairly extensive decision citing the case law, going through the case law, going through the arbitration clause, how did the arbitrator act in manifest disregard of the law in rendering his decision?
There are a couple of ways, right? So the standard here is that he knew of a governing legal principle, yet refused to.
I'm sorry, he what?
He knew of a governing legal principle, yet refused to apply it.
So what legal principle did he refuse to apply?
So
I mean, there's a number of Supreme Court cases
Right, so we-
that talk about this. How did he not, how did he manifestly disregard that case law in rendering the decision he did?
So I think it's a combination both of the Supreme Court cases and the line of cases that came out following Lamps Plus, where courts and arbitrators looked at arbitration agreements very similar to the one here, and
But
they
in
said
Lamb
without
Plus,
any.
it was basically a bilateral arbitration clause because it talked about I, me, the company, whereas here it's a pretty broad clause that we have here.
The language actually was quite similar in that it referred to all claims arising out of the agreement, and this agreement, which I do think is similar to the language that we have in the parties' agreement here, and is also extremely similar to all of the cases that came out following Lamps Plus, where the arbitration language was substantially similar to what we have here. And all of those courts said, including the Northern District of Illinois, that looked at the exact same arbitration agreement that we have
There's
here.
no, Lamps Plus is the last Supreme Court case in the trilogy of Supreme Court cases, and nowhere in that decision did the court say that in this type of arbitration clause, what was the broadest type of arbitration clause, but did not say anything one way or another about class action arbitration, that was prohibited from finding that class actions were covered by it. There's nothing in Lamps Plus that created a rule that it's not covered. So why is that a manifest disregard based on Lamps Plus to find that the arbitration clause did cover class actions in this?
You're correct, Your Honor. It didn't say that in Lamps Plus. But if you look at Lamps Plus and all the cases following Lamps Plus, and the courts and the arbitrators' review of the arbitration agreements, and those courts and arbitrators have found that if there's not a clear manifestation of assent to arbitrate, which those courts have said really is something.
How do you interpret this arbitration clause as not permitting the arbitrator? And it's the arbitrator who decides whether the dispute is to be arbitrated or not. How do you interpret the arbitration clause that you have in this case, which appears at page 97 of the record, as not permitting the arbitrator to come to the conclusion that you can have class arbitration?
Well, I think here
that clause is again and again, any and all, of any nature, directly or indirectly, out of or in connection with disagreement. It speaks in such broad terms, turning this over to the arbitrator.
So a couple of ways. First, Your Honor, I think the other cases that have looked at that type of language have concluded that that language really gets to the substance of the claims that are being arbitrated. Is it a tort? Is it a contractual claims? Do those types of claims come under this agreement? I think second, Your Honor, and the issue that I haven't been able to get to yet is that we have Nevada law controlling the interpretation of this contract. Nevada law is clear that where there are two reasonable ways to read a contract, if the contract is capable of a double meaning, then that contract is ambiguous. And under Lamps Plus, ambiguity is insufficient to compel class arbitration.
Does the standard of manifest disregard of the law require that the arbitrator get it right?
I don't think that the arbitrator has to get it right, but the arbitrator can't flout the controlling law. And here we have Nevada contract law that applied to this contract, which the arbitrator acknowledged applied to his contract interpretation, that says double meaning is ambiguity. Lamps Plus says ambiguity is insufficient. He identified two conflicting lines of case law. He said, this type of arbitration agreement has been looked at by many courts. Some courts have looked at this language and have said, this comes out a way that's more favorable to Mr. Eisencraft here. And other courts have looked at very similar language and have said, that has come out the way that my client reads the contract. That is the definition of ambiguity. When you have two conflicting lines of cases.
Is ambiguity the same as manifest disregard of the law? If there's conflicting case law, or judges have taken conflicting interpretations, how does that constitute manifest disregard of the law?
It is manifest disregard of the law under Lamps Plus, because when you read Lamps Plus, which he conceded was laying the ground rules for how he needed to look at this agreement, and Lamps Plus says ambiguity is insufficient to compel class arbitration. You have to have an affirmative manifestation of assent, and ambiguity is not enough. And he says there are two reasonable interpretations.
He gave many reasons in his decision why this was a broad arbitration clause and did cover class actions. And your main argument, it seems to me, why it's not is because it doesn't specifically say it covers class actions. What was wrong with him going through all the reasons he found this to be the broadest possible arbitration clause so that it would cover class actions? What was manifest disregard in that analysis?
When Nevada law controls his interpretation of the agreement, and the Nevada law says if it's capable of two meanings, then it's ambiguous, and he looked at
So what's the ambiguity? Other than the fact that it doesn't actually say that it covers class actions, what's the ambiguity?
That is the ambiguity, right? There are conflicting lines
Right, but
of cases that
we
look
already
at-
said that there's no black letter rule that you never are going to find class action where it doesn't say it.
Well, every single court and arbitrator who has looked at this after Lamps Plus has found that it is insufficient to compel class arbitration without more, without that affirmative assent, without that explicit language. And although Lamps Plus doesn't go so far, that is how courts and arbitrators following Lamps Plus have interpreted that case. And here we have Nevada law again saying if a contract is capable of two readings, it is ambiguous. He said, I'm looking at cases that fall on each side of the line. That is ambiguity. And under Lamps Plus, ambiguity is insufficient. And so by flouting
Just
Nevada
because the
law,
arbitrator is considering two different lines of cases doesn't mean that there's an ambiguity. He's just following the two lines of cases and then concluded that there is no ambiguity with regards to this contract.
well, respectfully, Your Honor, he didn't follow either line of cases, so I'm gonna make up my own thing entirely. But the fact that there are lines of cases that he acknowledged that say you could read it one way, pre-Lamps Plus, you have to read it the other way, post-Lamps Plus. And then he says this is unambiguous when he had already identified that there are courts that looked at very similar language and arbitrators that had looked at very similar language and had come out two different ways.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Michael Eisencraft for the Mohawk Tribe.
Is there an ambiguity?
No, that's what the arbitrator found. That's what this court must respect. Lamps Plus and Stolt-Nielsen years ago made it clear that you do not have to explicitly say class actions are permitted under an arbitration clause. In one of the amicus briefs in Lamps Plus actually advocated for that rule, saying you need to say it, otherwise you can't have it. And the court in Lamps Plus chose not to follow the rule. And earlier in Stolt-Nielsen, it said that an implied agreement was just as the same as an explicit agreement to permit class arbitration. And here, under Nevada law, what ambiguity is like, you know, it's referring to a ship named Enterprise in the harbor, and there are two ships named Enterprise, so you can't figure it out. Here, the court could figure out what happened and did. And that's a factual finding about the intent of the parties. And what Scientific Games is trying to say is that we need to overturn that factual finding of non-ambiguity. And that's not permissible. We bargained for an arbitration here. And under Supreme Court's decision, Oxford Health, unless the arbitrator, you know, and there's no allegation here that the arbitrator did anything except in good faith. You know, there's no corruption, no partiality. Everyone agrees he did his best, and he issued an 18-page decision evaluating the contract, evaluating the intent of the parties, and applying the governing law. We all agree Lamps Plus is the governing law, including the arbitrator. And the arbitrator said, unless I find that the contract unambiguously permitted the parties to seek class arbitration, then I can't find it. But I find it does. That's a factual finding. That's the highest degree of deference. And this court and the court below it, as the court below correctly recognized, that's not the court's place to review that determination. It was a well-reasoned and we believe correct factual determination. And unless the court has further questions, I see the rest of my time.
Thank you.
I'll be brief, Your Honors, but the reason why this is so important and the reason why the arbitrator's award cannot stand is because if this award stands, it informs arbitrators that all they have to do to compel class arbitration is say an arbitration clause is unambiguous and purport to do some de minimis contract interpretation, and then their decision is going to be completely immune from judicial review. This is the rule that Mohawk is advocating for here. That is not the law, and that should not be the law. That would completely wipe out the manifest disregard standard. It would also completely gut Lamps Plus. This cannot possibly be what the Supreme Court intended with its decision in Lamps Plus, where it reiterated the point it has made time and time again over the last 20 years that class arbitration is a fundamentally different animal than bilateral arbitration and raises all sorts of significant due process concerns. And it can't be the case that an arbitrator can fundamentally change what the parties bargained for without any clear indication that that's what the parties bargained for, simply by saying the language is unambiguous. Thank you, Your Honor.
McKinney versus Empire State. Go ahead.
Afternoon, Your Honors. Adam Calvert for third-party defendant appellant, U.S. Roofing. The key issue, as far as my client's concerned, is the indemnity clause between U.S. Roofing and Tishman and the court's interpretation of it. So here, the relevant portions of the indemnity clause are that the plaintiff's claims must arise out of or result from the acts or omissions of U.S. Roofing in connection with the contract documents, the work, et cetera. Now, the lower court, after the motion to re-argue decision, did find that they got it wrong the first time, but still did not get it right the second time. They got
Let me ask
halfway
you,
there.
that basically is the broadest clause you can have for indemnification arising out of. It doesn't get any broader. There's really no conditions other than it arises out of. Why in this situation where it's undisputed that the person who was injured was a U.S. Roofing employee doing his act of his employment, why wouldn't that be arising out of the actions of U.S. Roofing when an employee was injured doing his work for U.S. Roofing?
Well, Your Honor, if they wanted it that broad as you proposed, then they could have taken out the acts or omissions language, right? So,
But it's acts or omissions.
right, but that still requires a causal connection. It requires negligence.
Why does it require negligence? I mean, because clearly there are many indemnification clauses which clearly do have a requirement of negligence, and it's very easy to put in a negligence requirement. You just have to say arising out of the negligence. But this one doesn't have any language at all which talks about negligence. It just says arising out of. So how do you jump from arising out of an act to requiring negligence?
Well, Your Honor, if they wanted it that broad, they could have just said arising out of U.S. Roofing's work. But they said arising out of or resulting from the acts or omissions of U.S. Roofing's work. And
What's
that
the difference?
Well,
You just presented two opposite. What's the difference in the two things you just stated?
well, arising out of the work just means it has something to do with the work. But
Right,
arising
so
out
how could it possibly not be arising out of the work where an employee of U.S. Roofing was injured while he was doing his work?
because it requires some sort of act or omission in doing that work. There has to be something that U.S. Roofing did wrong, or something that
Where
they
does it
didn't
say
do.
that?
Sorry?
Where does it say that?
The acts or omissions language itself. That's what's saying it. By including that, you're
reading acts or omission to be a wrongful act?
some sort of act, not even negligent. It
Isn't
has
the
to,
act just doing his job?
no, it has to be something that they did or failed to do in connection with the job, that U.S. Roofing failed to do or didn't do in connection with the job, not just the sheer fact that the employee was injured in the job. Here, the lower court found that that was done in the scaffold inspection requirement of the contract. Now, that portion of the contract doesn't call for any sort of inspection of the issues that the plaintiff alleges was wrong with the scaffold. Doesn't require U.S. Roofing to check the height of the scaffold, doesn't require them to check for any other sort of issues that he's claiming in this case, or the lighting, which he's also claiming was wrong. Here, the only arguable portion of that is that they have to inspect the anchorage of the scaffold, which he's not claiming was a defect. So even if you read it as the lower court did, as just requiring that the claim be related somehow to the work, here that's not met because the scaffold inspection requirement in the contract doesn't, the U.S. Roofing didn't fail to do that. And that portion of the contract doesn't call for anything related to what the plaintiff's claims are. Finally, I would point out that even if accepting the lower court's ruling is correct, I think the conditional indemnity award was inappropriate, and I think that that's fairly clear under this court's case law, which says that if the indemnity is arguably liable, and here Tishman's
Right,
labor
but the
law
whole
200
idea of
claims-
conditional, it's the only time you're precluded from conditional is if you're 100% liable. And I don't know what would be the argument in this case that Tishman could ever be 100% liable, because if it's liable for the lighting, inadequate lighting, and the scaffold design, which other people would be liable if that's found the case. So they're never going to be 100% liable no matter any scenario. So why isn't conditional correct?
Well, so 2 points there, Your Honor. One, the case law is pretty clear. I think that if the GC, like Tishman, still has a labor law 200 claim against it, then there's a question of fact about its liability. So at that point, it's too early for conditional indemnity. And Tishman, as the GC, also has duties to the plaintiff under Labor Law 241.6, Labor Law 200 as a GC that the other contractors like Atlantic and ADCO, who are responsible for the scaffolding, for the lighting, do not have.
Thank you.
So it could still happen. Thank you.
I think it's Atlantic next.
Jonathan Wager from French and Casey for Atlantic Scaffold and Hoisting.
For whom?
So
Atlantic?
this didn't arise out of Atlantic Scaffold's work. Plaintiff says he ducks under Atlantic Scaffold's work, the pipe scaffold, and then hits his head on something that he can't identify. He doesn't know what it was, doesn't know how long it's been there, who put it there, or anything like that. So there's no proof of arising out of Atlantic.
Isn't there an
Atlantic
issue of
Scaffold.
fact in this case, though, about whether there was sufficient clearance on the scaffold? His claim is that he hit the scaffold when he got up because it wasn't high enough. And it was your client who put in the
Actually-
scaffold, so why isn't there an issue of fact based on that allegation?
Because, Your Honor, he didn't say that he hit the scaffold. He said he hit something that he didn't know what it was. It might have been a platform, might have been something else.
What else would it be there?
He didn't know.
What else? He was on the scaffold. What else would he have hit?
Well, it could have been somebody that hung something off of it. Who knows? He didn't know. That's the main problem here. He didn't know what he hit his head on.
Doesn't it leave
How
an
long
issue?
had it been there?
Doesn't it leave an issue of fact? I mean, it's your motion and you have the burden.
Well, it's clear that it's not the scaffolding. He didn't hit his head on the pipe. He ducked under it, hit his head on something else. He didn't know what it was.
How do you
But it
know it's
wasn't the
something
pipe.
else? You keep saying something else. What's the basis for the assertion?
Because that's what he said. He said, I hit my head on something. He didn't know what it was. It wasn't the pipe because he had ducked
Do you know it
under
wasn't
the
part of
pipe.
the scaffold? How do
I
you
beg
know?
your pardon?
How do you know it wasn't the scaffold? You keep saying it was something else.
Because
I
he
mean,
didn't
what
say.
else would it be? I know that you could hypothesize or speculate that it's something
Well,
else other than the
well, he
scaffold.
didn't say it
but how
was-
can you prove as a matter of law that it was not some part of the scaffold?
Because he didn't say it was part of the scaffold. He said it was something.
Okay, we can have your argument. Thank you.
Thank you.
May it please the court, Mary Azaretto for Tishman Construction. First, turning to the Labor Law 241-6 claim, plaintiff's admission on 3 occasions that he was able to see the steps in front of him and that he had no trouble seeing where he was going due to lighting, in and of itself was fatal to the 241-6 claim. Nowhere in the record on appeal was there any testimony of any kind to indicate that darkness made it unable for him to see where the steps were.
Wasn't that part of his testimony that the accident occurred because it was dark and there were no lights and he couldn't see where he was going? Didn't he testify to that?
No, he specifically testified that he was able to see where he was going and had no difficulty seeing due to lighting. At a later point in testimony, he vaguely referenced darkness, but he never actually says or connects the darkness to an inability to see. In fact, just the opposite. There are 2 cases that are cited in my brief, Cahill and Bradley, that were decided by this court, where similar vague testimony was not sufficient to establish liability. He was clear in his testimony. He saw where he was going, he knew the steps were there, and he simply cannot rely on that industrial code provision based upon that admission, which he made, I believe, 3 times during the course of his deposition. Turning to the 200 and the common law claim, plaintiff is a 6'4" individual walking through a standard 6'2" door frame. The mere fact that the plaintiff was a tall individual does not render an otherwise standard doorway defective. He was well aware it was there. In fact, he ducked his head. As he testified, he always has to duck his head because of his stature. The mere fact that he struck his head on it is not sufficient to create a defect. Without a defect, there's no analysis as to whether there was a notice of a defect. Therefore, the lower court's discussion with regard to time of last inspection open and obvious. It was all misplaced in this case. We don't get to notice unless we first have a defect. And simply put, the mere fact that he was taller than your
Again,
average
why
worker.
isn't there an issue of fact about whether it was defective? Because you should have working conditions where all workers can be safe. And he says he did duck, and it was when he got up from ducking that he hit his head. And why doesn't that testimony create an issue of fact as to whether it was the scaffold was unsafe? Or, because it has to be safe for everybody, however tall you are.
Well, it wasn't necessarily unsafe just because of the fact that he had to duck.
No. He testified that he ducked as he knew he had to, but when he got up, his head hit something.
Right.
So doesn't the workplace have to be safe for people who are 6 foot, 5 feet, 6'4"?
It would be a factual impossibility for the GC to be able to ensure that the workers went fully through before they actually stood up. There's really nothing that could be done to prevent that. And to hold that we should be required to have doorways that are 10 feet tall to accommodate the most largest of individuals would be unreasonable, in my opinion.
Isn't there also a light issue? Didn't the plaintiff testify that it was dark in the area? I know there's countervailing testimony that it was well illuminated. But doesn't that create an issue of fact?
He referenced darkness, but he does not specifically say that the darkness caused him to not be able to see. But if you look
Does he have to specifically say that?
Well, he does, because he was specifically asked earlier, did you have any difficulty seeing where you were going due to lighting conditions? The answer was no. The inquiry should have ended there. Anything that came after was nothing more than an attempt to create a question of fact based upon an earlier admission. Briefly, just as to the indemnification claims, I strongly urge this court to hold that there are no questions of fact with regard to the labor law claims, but in the event this court is to hold there are such questions of fact, Tishman is entitled to contractual indemnification from all the defendants based upon the very general
What
language in the
about his
contract.
argument that somehow negligence is required under these indemnification clauses?
Well, as Your Honor pointed out, there's no specific reference. That's him simply reading it into the statute, which is not there. But not only that, the language of all of the contracts makes clear that we're to be indemnified for any claims of their acts or omissions. That's
Is your
exactly.
argument, I'm sorry, is your argument the same with respect to ADCO and Atlantic in terms of the indemnification clauses, that they're similar clauses and should be interpreted broadly?
The argument is the same with regard to all the defendants. It's just slightly different in the sense that ADCO and Atlantic did actual work to the areas that are alleged to have caused the injuries.
Right, so if you're found liable because of the lighting condition or because of the way the scaffold is designed, that you'd argue that the contractual indemnification would then come into play, I assume, against, for the same reasons as against both of them.
I'm sorry, you lost me there.
You have a claim against ADCO for contractual indemnification. You have a claim against Atlantic for contractual indemnification. Are you making the same argument that if you're found liable, either because of inadequate lighting or the design of the scaffold, then you should get indemnification?
Based upon the claim that's being made in this case. Although, again, I do emphasize that I do not think there are any questions of fact with regard to any of the defendants in this case.
Thank you.
Thank you.
Good afternoon, Your Honors. Anthony Lagara on behalf of ADCO. A lot of my presentation dealt with the lighting conditions, which were addressed by counsel for Tishman, so I'll abbreviate it somewhat. If the panel has no objection, I just want to read 3 questions and 3 answers from the deposition transcript. When you were going through, from plaintiff's deposition, when you were going through the entryway, were you able to see the staircase? Answer, yeah, I could see the stairs in front of me. Question, okay, you had no trouble seeing visually, seeing anything at that point. Answer, right. Question, were you able to see anything? Answer, I could see, in front of me. I could see the steps in front of me. So given this testimony...
Isn't that a different time period that's being talked about? That's when he's first approaching the steps versus after he ducks down to get under the barrier and then comes back up again. Isn't that a different time than a different space?
Obviously, it's a different time, but it's a near instantaneous course of events. He has no problem seeing the staircase as he approaches the threshold. He ducks down to get underneath the doorway, and then immediately as he straightens up, the top of his head strikes something or some component of the staircase. So therefore, as he approached the staircase, he had a clear view of everything that was going on to his intended destination. There was never any testimony or any evidence that that there was anything preventing him from seeing that number one, he ever saw the structure that he struck his head on, or he would have been able to see it had the lighting conditions been arguably any different. So therefore, respectfully, I think the Supreme Court erred in denying the motion as to Labor Law 140 based on Rule 1.30. And just the only other thing I would add on that point is, as counsel alluded to earlier, there is case after case from this department where vague terminology, such as it's kind of dark, it was poor, or using similar language by a plaintiff to describe the lighting conditions, is insufficient to establish a violation of the regulatory standard. With respect to the contractual indemnification claim that Tishman has against ADCO, ADCO is in a different position than U.S. Roofing because we were not the employer. They were the electrical subcontractor. And
Isn't the claim that if they're found liable because of inadequate lighting conditions, then the contractual indemnification clause would come into play since it arose out of your work in terms of the lighting?
That may be correct, but there has been no argument by Tishman that, in fact, Tishman has argued the opposite, that there was no problem
Right, but they're
with the
allowed to
lighting
argue in the
conditions.
alternative at this point.
Thank you.
Thank you.
Good afternoon, Your Honors. Adam Hurwitz from the Perisford Firm on behalf of the plaintiff respondent.
Why don't you respond first to, there's been much discussion about the lighting and his testimony about the lighting and that it wasn't really dark. Why should those lighting allegations go forward in this case?
Yes, Your Honor. As Your Honor indicated, the area where plaintiff allegedly said there was some lighting conditions and didn't have a problem seeing was not in the immediate vicinity of where the accident happened. I believe there's a conflation of locations of where the testimony was about the lighting. There's a series of questions asked about the walkways, which is the area leading up to the entranceway to where the scaffold was. The entranceway, which I think also was referred on the record at times as the doorway, and then the immediate area where plaintiff's accident happened. Now, plaintiff did say that he could see the stairs in front of him, but he did not say that he could see the scaffolding and the low-hanging scaffold, which is an entirely different area, which would be above him, which might have been illuminated by lights if they were there, and there's a question of fact whether there was any lighting in the area, and also that low piece of scaffold could have been spray painted, as was suggested, and
What
was...
about the claim of Atlantic that it's unclear exactly what he hit his head on when he got up, whether it was
Well,
the scaffold or something else that he hit his head on?
I think it's beyond the pale to suggest that there was something other than scaffolding that he hit his head on. And indeed, Mr. McKinney testifies at page 370 of the record that when he was asked whether he was able to observe what he was able to observe when he looked up at the piece of scaffolding, he said it looked like a part of the scaffold. And when he was asked to better identify what he saw when he looked up at that area, and this is record 370 and 371, he says, I don't know, it was kind of dark out. There was no lights or anything in there. I believe the lower court got it correct in indicating...
What's your response to the argument of Tishman that the plaintiff was particularly tall and there was nothing inherently wrong with the way the scaffold was built? Plaintiff was just tall and got up too quickly.
It's almost akin to an argument that my client, because of his stature, was the sole proximate cause of the accident. And we know, based upon the accident investigation conducted by Tishman, that there was a finding that this was low scaffolding. And there was a finding that if it was, and there was testimony from Tishman, that if it is low scaffolding, yes, we would want to put up signs. And we might even want to spray paint the low-hanging scaffold. And according to Tishman, There were signs there. So if there is low hanging scaffold and a sign's up there, that's not typical of what else is on the site. Otherwise, there would have been evidence brought into this case that all over this large project, there were signs and spray paint.
So, counsel, low scaffolding means here, for our purposes, that the opening didn't meet the standard 6 feet 2 inches?
No, low scaffolding is that it was below what would have been reasonably safe under the circumstances. It then constituted a potential danger for which proper illumination and signage and other measures should have been taken.
Okay, thank you.
Thank you.
Your Honors, I'll be very brief. I'll just work my way backwards here, starting with the conditional indemnity argument. I'd like to point out that conditional indemnity was not granted to Tishman on its claims against ADCO or Atlantic, who had the same indemnity provision and who were actually responsible for the scaffold, designing the scaffold, and lighting the scaffold. Yet the court granted it as to my client, who the only alleged fault in this case was the fact that the plaintiff worked for them. So if it's...
Isn't the distinction that as to both the lighting contractor and the scaffold, Tishman would only be found liable based on the actions of others, whereas to United Roofing, Tishman could also be held liable based on its own negligence?
I would argue, and that would make my argument even stronger. Why am I...
That's why it's conditional. That's why they don't get total indemnification, they get conditional.
They didn't even get conditional against Atlantic or ADCO, who were actually doing the work and actually designing the scaffold and actually putting up the lighting.
Because we don't, I won't explain to you why they're not, but okay, thank you.
Okay, thank you, Your Honors.
I'll just briefly point out that the accident report that Respondent's Counsel mentioned does not actually state that the scaffolding in the area was low. In fact, there was no characterization whatsoever in that unauthenticated accident report of what the conditions looked like at the time. There was a hypothetical question, what could have been done differently in the area, and the answer was spray paint, and I believe spray paint, which again would have made no difference to an individual who was well aware that it was there, knew he had a duct, and in fact did so. Thank you.
Thank you. Valada versus A.O. Smith Water.
May it please the Court, Christian Gannon, Siegel McCambridge, on behalf of Appellant PB Heat LLC. Your Honor, we're here on 13 consolidated appeals from a denial of our motion to dismiss, where we believe the Court incorrectly found that PB Heat LLC is the successor to Peerless Industries in each of these actions. The respondent has failed to have any factual basis or legal basis for any of the exceptions for successor liability.
Let's start right there, because it's your motion to dismiss. So all we look at is the pleadings. They don't have to raise a factual issue. It's your burden to show that there was no successor liability as a matter of law for you to satisfy that. And we know that in these asbestos proceedings, it's not the same pleading requirements as there are in other cases. So it's not the normal CPLR standard of them having to plead the allegations they would in a regular lawsuit. So how have you met your burden of establishing that successor liability does not apply as a matter of law, and that none of the 5 exceptions that potentially exist for successor liability do not apply in this case?
Okay, Your Honor. I think that the motion to dismiss was based upon documentary evidence. I think the confusion in the case is there's more than one Peerless Heater company. So in 1964, American Management Company merges with Peerless Heater Company, and that forms Peerless Industries. That company is in existence all the way until 2019 when they run out of insurance. In 1957, there's another company formed called Boyertown Products Company. By 1997, Peerless Industries...
What's Robert Fisher's role in all of this?
Robert Fish is the individual, he's one of the three investors who buys Boyertown Products in 1997, which is that...
Is he involved in all of these entities?
No, he is not. The only entity he's involved in is he purchases Boyertown Products, which is, by 1997, the Peerless Heater Company. And after that, he reorganizes the Peerless Heater Company into Atlantic Shores and PB Heat. He has nothing to do with Peerless Industries. He has nothing to do with Boyertown Products in 1957 up until he buys it in 1997. So Robert Fish only appears on the scene in 1997 when he buys the stock from Peerless Industries of Boyertown Products, which at the time was called Peerless Heater Company. And at that point in time, Peerless Industries retains the liabilities from pre-1997. Peerless Industries stays in business. They get their first asbestos lawsuit in 1981. They continue to handle the cases and resolve them. At the time of 1997, they continue to handle the case and resolve them. They don't dissolve at all. At the time of the 1997 transaction, they are still in existence. In 2003, during the tax reorganization, Peerless Industries is still in existence. And during the entire time from 1964 until they run out of insurance, they are an active company. They're not dissolved, and they're settling all these cases.
How does the Pennsylvania product line exception work with your position?
I don't think it applies, Your Honor. And the reason I don't think it applies is because Peerless Industries never goes out of business. And the creditors or the plaintiffs always have a source of recovery with Peerless Industries. It's not as though the liabilities or the stockholders went over to PB Heat and Atlantic Shores. Peerless Industries was always a source of recovery for all the plaintiffs from 1981 until 2019, when Peerless Industries exhausted its primary and its excess insurance policies. And it's only at that point that plaintiffs' counsel says, well, now PB Heat must be the successor. That would completely turn corporate law on its all the way upside down, because it's clear all the way through the liabilities for the asbestos claims from 1981 until 2019 were always satisfied by Peerless Industries. Never satisfied by PB Heat, never satisfied by the second Peerless Heater Company, never satisfied by Atlantic Shores. So in the entire time, the liability stays where it was. Robert Fish has nothing to do with the other companies
You
whatsoever.
don't prevail on this appeal. All of these issues that you are raising remain in the case, right?
Well, Your Honor, the difficulty with...
Subject to further fact-finding.
Well, I believe on the record before the court and the corporate documents and the merger documents, it's clear that the liability always remained with Peerless Industries. What's interesting about the respondents' argument, I anticipate today, but also in their brief, they completely skip over the 1997 transaction. They make no mention of it whatsoever. They assume that the Peerless Industries that was purchased by Mr. Fish in 1997 was the legacy Peerless company from 1964. That's not the case. It's a totally separate Peerless company. There were two separate Peerless companies in existence that are in play in this litigation.
Thank you.
Good afternoon, Your Honors. Pierre Ratsky for the plaintiffs' respondents. On the first point in the appellant's appeal, that the complaint did not adequately allege a cause of action. As Your Honor correctly pointed out, we use standardized complaints in NICAL, and our standard complaint did list all the Schumacher exceptions.
What about their second argument that, looking at the documentary evidence, that there is no basis for this claim of successor liability in this case?
Oh, well, we disagree, Your Honor.
Why are they incorrect in that argument?
They're incorrect if you, and I will address the 1997 transactions, which my opponent said I would not address, but I will, which was raised for the first time in their reply papers more substantively. But in that 1997 stock trade, they claim that that severs the chain of liability. But that stock trade was not, that stock sale rather, was not an arm's length transaction. If you look at page 794 to 795, the deal was signed off for by Mr. Robert Fish. So he seemed to have been on both sides of the ledger. If there's any ambiguity as to his role in all of these companies, that ambiguity militates in favor of affirming the decision to deny the motions to dismiss at this early stage. Also on page 801 of the record, it makes clear that the indemnification of PHC by Peerless Industries was temporary. It said that it shall only be effective for 10 years and shall be for no more than the amount that seller receives under this agreement, which was $300,000. So if this is intended to be a permanent indefinite indemnification and Peerless Industries was intended to always and forever hold these liabilities, then why would it have an expiration date and an amount cap? So that does not sever the chain of liability, and these other exceptions still do apply, namely mere continuation. Through those series of 2003 transactions, Mr. Robert Fish created a shell corporation, Atlantic Shores, which was intended not to survive the transaction, but merely to be a vessel through which to pass the liabilities on to PP Heat. And so the mere continuation exception here applies, and Justice Silvera was correct to recognize that. Same with de facto merger. All the elements of de facto merger are present here. That applies when it is in effect the intent to completely take over a business. And it's important to note that PP Heat continues to manufacture boilers under the Peerless brand name. And they acquired all of the trademarks, goodwill, business operations, everything necessary to keep the Peerless business going. And so all those factors point to de facto merger here, including continuity of ownership, since Robert Fish was on both sides of this transaction. Alter ego liability also pled in our complaint, and I don't believe it was addressed below by Justice Silvera, but that provides another basis for finding liability here. There doesn't seem to have been any recognition.
Right, but we're not going to address that since it's not part of the appellate record.
Fair enough, Your Honor. And again, as Your Honor raised, the product line exception, that applies as well. All of these contracts in the 2003 agreement and the 1997 agreement, for that matter, chose Pennsylvania law as their governing law. And that state recognizes the product line exception. And this is a perfect example of why that exception should apply, because they're still making the same type of product, which is Peerless brand boilers. If there are no further questions, we'll rest on our briefs. Thank you.
Thank you.
Your Honor, I would urge the court to examine the 1997 agreement between Peerless Industries for the Peerless Heater Company, which was Boyertown Products, and Robert Fish. Robert Fish is not on both sides of that transaction. Peerless Industries owned 100% of the stock of the Peerless Heater Company, sold it to Robert Fish, and they retained the liabilities before 1997. So there's no double dealing, there's no on the other side. In terms of the de facto merger factors, he hasn't met any of them. There's no continuity of ownership when it comes to PB Heat and Atlantic Shores. Peerless Industries did not cease business as soon as possible after the transaction. PB Heat and Atlantic Shores and Mr. Fish did not assume liabilities of Peerless Industries in 1997, and they never have. In fact, in the 2000 agreement, they reiterate that they have no liability pre-1997, and there's no continuity of management, personnel, physical location. Peerless Industries stayed in business. They continued to operate as a company. They never dissolved. They continue to be responsible for all the liabilities for the asbestos claims. So there is no creditor or plaintiff at this point who is out of luck recovering in a case. What's happened is that they finally ran out of insurance. $135 million later, the primary and excess liability insurers are done. So the liability has always stayed on the Peerless Industries side. That's where it remains since 1964 until 2019. The company never dissolved. PB Heat never had any responsibility for that. Thank you very much.
People versus Jimenez.
Good afternoon. Benjamin Rutkin-Becker on behalf of Pedro Jimenez. The lower court should have suppressed Mr. Jimenez's post-arrest statements regarding his identity. We do not contest that in the run-of-the-mill case, officers can ask an arrestee their name under the pedigree exception to Miranda.
But counsel, at the end of the day, the statement, in essence, went to his identification as Pedro Jimenez, as opposed to what any other alias that he was using at the time. But was that what led ultimately to his conviction, or was it something else?
It was a critical component of his conviction, Your Honor. The proof in this case, to begin, was far from overwhelming. The crux of this—
Far from overwhelming? All of the witnesses knew who he was. They knew him from when he was in the neighborhood in 1990 and before. They all went to school together. They grew up together. They knew each other. They visited at each other's homes. They were constantly with each other, and they recognized him on the date of the incident as being the shooter.
So they did know each other from the neighborhood. That's right, Your Honor. At its core, this is a single witness identification case. There was only one witness, Eddie Sanchez, who's
One witness that saw the shooting, but then there are other witnesses that knew the relationship between Mr. Jimenez and the victim, and who saw Mr. Jimenez and that knew that they had some type of, let's say, argument over a certain piece of real estate that they were both arguing over, and that saw him on the date of the incident do certain actions other than shoot him that ultimately led to the conclusion, aside from some of them seeing him do the shooting, that he was the actual shooter.
a few things, Your Honor. So as to the dispute, it's actually telling that De La Cruz, the sister of the decedent, says that she learns of the dispute only afterwards, this alleged motive, from gossip in the neighborhood. And that goes to some of the main problems with this case. This really is a single identification case. The additional
There's also
witnesses...
the fact that he's living up in Liberty under a different name.
And fled the same day as the murder.
So that goes to the importance of the consciousness of guilt evidence in this case. When what we otherwise have is a witness coming out of the woodwork after 30 years, the consciousness of guilt evidence was very important, far more important in this case than it generally is. And this statement was the critical piece of consciousness of guilt evidence because this was the only statement that went to Mr. Jimenez's
What
own...
about the fact of coming back to this issue that the person who asked the questions was not the investigating officer? It really was literally another officer at the station just taking pedigree information. Why then does this implicate any issues?
Because that officer was briefed as to what was happening, as to the fact that Mr. Jimenez was going to be brought in from Liberty. The arrest had to be processed in New York. And this goes to what makes this case...
The officer was only told that it was a cold case, right? There's no evidence in this record that that officer was told that this defendant was living under another name, had constructed a whole nother life. That detective was not aware of those facts, correct?
The officers who testified at the hearing were not the officers who personally spoke with this officer. So that is correct. We don't know exactly what he was told. However, we know he was briefed about what was happening, and we need to look at the context.
Detective DeGrazia know what the defendant's name was?
On this record, there's no testimony of exactly what he told. I think the fairest inference is that he was, and it's the prosecution's burden to establish the legality of the conduct here. And it is helpful to look at the full context of the police conduct here.
But you start with that this is typically pedigree information, so hasn't the prosecutor met their burden with that? And then it's for you to come forward and say, well, no, this isn't pedigree information because Detective DeGrazia knew that it was Pedro Jimenez that he was dealing with.
No, Your Honor. So there are two things that make this record that we have very distinct. And that's one, that this was a pre-arranged arrest. The officers in the Bronx were briefed that Mr. Jimenez was going to be coming in on this day. It is true that we don't know exactly what they were told, but we know this was a pre-arranged arrest, and we also know that the officers, from the very moment of their interactions with Mr. Jimenez, they opted not to get an arrest warrant, they opted not to Mirandize him, and they clearly were trying to get him to say something inculpatory, and that should not change after he's invoked his right to counsel.
Thank you.
Thank you.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors. Counsel.
So getting the defendant to state that his name is Pedro Jimenez is very damning to the defendant. How is that not custodial interrogation?
It is custodial interrogation, but the question falls within the pedigree exception.
Isn't that question, isn't it reasonable to conclude that that question was aimed at an investigation rather than just simply pedigree?
No, I mean, the question, what is your name, is sometimes significant. It sometimes has
Here it's
evidentiary
significant, right? He's
value.
living under Vincent Vega, Manuel Sosa, all these other aliases, and what you need to prove here is that he's Pedro Jimenez.
Well, here in this particular case, there was lots of other proof that his name was Pedro Jimenez. So ultimately, it didn't matter in this case.
So you're saying harmless error?
If it was error at all, it was most certainly harmless error here.
What other proof was there that he was Pedro Jimenez?
Well, you had testimony from Cynthia de la Cruz. You had testimony from Carlos Villatoro. You had testimony from Eddie Sanchez. They all knew him as Pedro Jimenez. So these were people, as was pointed out, who grew up with him. I mean, opposing counsel describes this case as a single witness identification case. It's not an identification case at all. The people knew who he was. This was not some fleeting encounter and the only basis from which they could possibly recognize.
The detectives who questioned him in Liberty knew that it was Pedro Jimenez, didn't they?
Yes. Yeah, they already knew.
It's then Detective DeGrazia comes in to the scene a little bit later, right? And
that's correct.
Down here, down in New York. And do we know what he knew?
There's no evidence that he knew anything about the investigation itself, or that the name that the defendant had been using, had been living under the name Miguel Sosa, or been living under the name Vincent Vega. There's no evidence that he knew that the name Pedro Jimenez was itself significant. But you know, there are.
Is it out of the ordinary that Detective, I forget his name, DeGrazia, the one that asked him his name, the pedigree, why wasn't the defendant processed by the officers that got him?
I can't answer that question, why the New York City Police Department would have handled this arrest as opposed to the investigators from the Manhattan District Attorney's Office who brought him down and would have, I suppose, could have brought him to some other precinct. I don't know what the logistics were within the NYPD.
The investigators were present when the NYPD detective asked the pedigree question, correct?
That's correct. That's correct. But I would point out that this was not an identification case. This was not really even a single witness case. As was discussed during my adversary's argument, Eddie Sanchez was the only witness who testified that he actually saw the shooting. But Cynthia de la Cruz and Carlos Villatoro, they saw the defendant going to the scene just before the shooting. They saw him rushing from the scene right after the shooting. There was extremely strong circumstantial evidence, even apart from Eddie Sanchez's testimony, that the defendant was the shooter. I mean, the detective from the night of the shooting was looking for the defendant because he was placed at the scene of the shooting. And by the way, it was his brother who came from the shooting and told Carlos Villatoro right after it happened, Pee-wee shot Mario, Pee-wee being the defendant. So you had all this other evidence pointing to the defendant in the first place, and then Eddie Sanchez's eyewitness testimony was, of course, extremely compelling, but it was also extensively corroborated by the other witnesses' testimony, along with the testimony from the police who investigated the crime, from the medical examiner who performed the autopsy and testified about the number of bullets, the location of the bullets, the entry wounds that all matched up with what Eddie Sanchez described in terms of the positioning during the shooting, the distance that the defendant was when he shot Mario's.
Does the record reflect how the police came to realize that he was in Liberty?
It's a little bit unclear on some of the details. I'm not sure if all those details would have been admissible, but it's clear that they performed, they reinvestigated the case, reinvestigating all of the leads that the original detective had. So they re-interviewed people, and that included, I'm trying to remember how they came upon the name Vincent Vega. They spoke to a woman who had been living with the defendant's brother, and And I think it was the defendant's, it was that woman who tipped them off that they should look at someone named Miguel Sosa when they, and that
Thank you.
that was actually the defendant.
Thank you.
So, as to the merits, the hearing court found that the detectives in Liberty wanted to obtain inculpatory admissions from Mr. Jimenez that linked him to this crime, and the hearing court rightfully suppressed his responses to continued questioning after he invoked his right to counsel. So the deliberate intention to interrogate Mr. Jimenez through supposed pedigree questions is clear here, and it should be of no moment that a different officer who, again, this is not the usual arrest circumstances. This is a highly pre-coordinated action where the officers know they're working as a team. They know that they're going to be arresting him in Liberty. They have probable cause. They don't get a warrant. They're trying to get something out of him. He invokes his right to counsel. And it should not matter that a different officer with a pen and paper then goes up to him and does the same thing once he's in the Bronx precinct and after the officers had made it clear exactly who he is.
Thank you.
Thank you.
Pinckney versus New York City Health and Hospitals.
May it please the court, Antonella Carlin for Health and Hospitals. Supreme Court erred in not dismissing the plaintiff's complaint as time barred. I just specifically want to address the continuous treatment doctrine and why it does not apply here. Mainly, the fact that the plaintiff filed a notice of claim severs any tolling that would otherwise be applicable. And here she filed it in June, just like a month after she was released from the hospital. And at that point, she also spoke to Dr. Butler and said she was
the merits of the continuous doctrine claim, putting aside the notice of claim argument. What is your argument as to why the continuous doctrine treatment would not apply in this case to make this case timely?
So at that point, when she filed the notice of claim, she also severed any continuous treatment.
But I'm asking you, separate and apart from your notice of claim argument, why is it not continuous treatment?
So she, at that point, also severed treatment when she was speaking to Dr. Butler. Right before she filed the notice of claim, she said she's never coming back. She wanted a note from her, and she said she's never coming back. She had a follow-up appointment that she missed, and she didn't come back for like 3 months, I think it was, around. And at that point...
Does that further treatment take place after the discharge instructions have been completed?
So I think her notice of claim suggests that it ends in May 6th, but I think, yes, it does.
She's told to do certain things after her discharge, and that comes to an end at a certain point with her last test, and then her going back further to the doctor is not a continuation of that treatment.
I think that's exactly right. So to the extent it continued after she was discharged, I think the last time was something related to it was August 2nd, maybe, 2013, or prior to that. And then after that, her visits are sporadic, and they're unrelated to what prompted the hospitalization in the first place. Even if you just consider it about the hypertension, she was being treated for acute elevated hypertension, right? So she was going to the doctor and having these blood pressure checks like weekly or bi-weekly, and they were adjusting her medication to try and get it right. That's wholly distinct from coming to a doctor now that you've gotten everything fixed and you just have chronic hypertension, and you go to a doctor for a yearly checkup.
Isn't that the pivotal issue? What is the malpractice that the continuous treatment would apply to? Does it apply to her being treated for hypertension, or does it apply to her going and getting the wrong medication and going into being forced to go into a coma as a result? What is the treatment that is continuous or not continuous?
So in this case, it's the the low sodium levels, because that's what she says is the reason why the doctor prescribed the wrong
When
medicine.
did that treatment end?
So that took place prior to the hospitalization.
Right, but she did have some follow-up visits related
So
to that
maybe
condition.
she had a urine sample taken, and there was stuff in, I think, June, maybe July at the latest, but it definitely ended before August 2nd. So that treatment definitely came to an end.
Did it end with the stress test that she took?
Sorry?
Did it end with the stress test that she took?
I don't think
compliance with the discharge instructions.
Yes, I'm not sure that she actually ever ended up taking the stress test, but she had like urine panels done to check on her sodium levels and stuff. And so I think that at that point, once that was all resolved, that's when the treatment came to an end.
Thank you.
Thanks.
Good afternoon, Your Honors. May it please the court, Daniel Robinson for Thelma Pinckney. Plaintiff responded. Ms. Pinckney asks that this court affirm the lower court's ruling which denied summary judgment. There are material issues of fact, including specifically continuous treatment.
Let's put apart the notice of claim again for a second and just talk about the continuous treatment doctrine on the merits. Why didn't any continuous treatment end when she finished up the follow-up specifically related to what she was admitted to the hospital for? Since the alleged negligence is not her having hypertension, it's that she had this condition brought upon by incorrect medication. Once she finished up the follow-up treatment for that, why didn't that end any continuous treatment, which would have been before the statute of limitations?
Yes, Your Honor. All elements of the continuous treatment doctrine were met, and I want to address each in turn, and I want to specifically say that before the lower court was the issues put before in the expert affirmation, which the opinion, which appellants take no issue with, the actual substance of the medical malpractice claim, laying out the elements. The opinion of the expert said that the treatment at issue was hypertension. The negligence was in the negligent prescription of a thiazide diuretic called chlorthalidone.
Right, so that's the malpractice.
Absolutely.
So if that's a malpractice, once she was finished with the treatment for the ill effects of that allegedly incorrect medicine, why didn't that end the continuous treatment for that episode, which is what caused her hospitalization?
Because the hyponatremia, Your Honor, is damages. The hyponatremia was caused by the negligent act.
Of the medication, of giving that
Yes, Your Honor, the
particular
negligent
medication.
administration of the thiazide.
So once she ended the treatment for that incorrect medication and did all the follow-up related to that, why didn't that end any continuous treatment with respect to this malpractice claim?
Because, Your Honor, she never ended the treatment. Ms. Pinckney was under treatment with Dr. Butler specifically for over 10 years about hypertension.
Why do routine visits for hypertension, which are actually 2 of the 3 of them are described as routine visits for hypertension, why would that be continuing treatment for being given incorrect medication, which caused her to go into a coma?
Because the hypertension cannot be dissociated from the hyponatremia. The thiazide diuretic itself attracts the sodium to be excreted. So the actual treatment cannot be unrelated to it. So when she...
Under that logic, she will never end treatment.
Well, may she live many, many years, but specifically the facts here, though...
So this claim, she could, in 20 years, this claim is still alive, is what you're saying.
Lord, I hope not, because we're scheduled for trial in the fall, Your Honor, but...
I understand, but you're saying that she's got a chronic condition, which is hypertension.
Yes, Your Honor.
She goes to the doctor, she gets prescribed the wrong medication. She ends up being admitted because she's now in a coma.
Yes, Your Honor.
She finishes the hospital treatment May 6th. Then she's given instructions to come back to follow up based on her previous condition that ended on May 6th. And she goes and she does a number of things, and then after that, her treatment is for her chronic condition, hypertension.
And appellates themselves note that even if we focus on the treatment for the hyponatremia, which I'm happy to focus on, treatment. She was discharged from the hospital on May 6th of 2013. She saw Dr. Butler on May 15th in the clinic of 2013. She saw Dr. Butler on July 12th of 2013. She does the stress test on July 22nd of 2013, and she's seen on October 14th of
Why isn't
2013,
the
all
stress-
for hyponatremia.
Why isn't the stress test the last thing that occurs in the course of treatment, though, for the hyponatremia? What happens after that?
Because every single time they adjust the medication, they have to assess what her sodium levels are. So they're
That's
always
just chronic hypertension treatment. As my colleague said, then she'd never be done with treatment. If you're going to call all hypertension treatment as continuous treatment of that condition, then she'll never finish treatment until she dies.
which goes back to the opinion of the expert, Your Honor, that Dr. Butler herself was always cognizant of the sodium levels of Ms. Pinkney when assessing what hypertension medicine to prescribe her. So we cannot dissociate the hyponatremia from the hypertension. They are all one and the same. And I want to note
July
that even
22nd stress test is the last thing that's done, which is part of the follow-up.
what a fall from the hospital, Your
Right.
Honor.
It's-
Even
happening
appellants note up
afterwards
to
is new treatment or continuing unrelated treatment.
Appellants themselves, to answer Your Honor's question, if I may conclude, appellants themselves note in their brief on page 17 that it is true that buried in Dr. Butler's notes from 4 of these 14 visits is the term hyponatremia. Even appellants note that through October 14th, which was well before the year in 90 from the filing of the summons complaint, that it was indeed satisfied and it was related to hyponatremia, though of course we argue that the hyponatremia cannot be unrelated to the hypertension because that is the opinion of the expert. Thank you, Your Honors.
Sorry. Unless you guys have any questions for me, I'm happy to rest on the briefs. I'll just note that we don't actually say that she continued getting treatment after August 2nd for the hyponatremia. There's nothing in our briefs that say that, and there's nothing in the record to support that. And if you guys have questions, otherwise, thank you.
Lynx Capital Partners versus Bays Capital.
Good afternoon. Jed Weiss for the defendants' appellants. In April and September of last year, the trial court took the extraordinary act of striking a pleading against parties, individuals, and entities against whom issue hadn't even been joined and were not the subject of a motion to compel. There was one substantive motion to compel in this case. It appears in the record 295. It's dated June 23rd, 2021, and it states that Lynx is entitled to documents from Bays relating to transfers or disbursements to principals or entities controlled by said principals. That order only applied to Bays. In October, following that order, the plaintiff brought an order to show cause. In that order to show cause, they proposed language that states, this court clarifies its decision and order of June 23rd and expanded that order to include the individuals and the entities that were subject of the motion to strike, as well as bank account statements, wire transfer records, text messages, email records, tax records, tax returns, etc. The judge struck that out. He struck that language. That's in the record at 311. However, fast forward to his decision. If you look at pages 4 and 5 of the trial court's order that leads to the court's decision, he says there was a failure to produce tax returns. But Bays didn't file any, nor were they ordered. He struck that language. Failure to produce bank statements, not ordered, crossed out. And also, in addition, it's not even true because we actually produced 120 bank statements from individuals and entities, documents, evidence, and conveyances.
What's your defense of the fact that you dropped 34,000 pages of documents without identifying to what requests they're responding?
We did that originally, and the CPLR provides for that because they were produced in the form that they're maintained by my client. CPLR says you can either you can categorize them or produce them in the form they're maintained, which is exactly what we did. When the trial court was displeased with that, he ordered us to categorize the documents, and we did. And we provided that. That was on January 7th. Not to mention, we worked hand in hand with the plaintiff throughout this process to create a set of search terms that would produce a productive production, so to speak, and produce an additional 3,000 documents same day, January 7th. At the end of the day,
That January 7th date, that's after the deadline of December 31st.
so in the oral argument transcript, when the court said produce the categorization and the additional documents, he did say by 12/31. And then he said, but if you need another week, and maybe he was considering the holidays, I don't know, email the part and you'll get another week. That's exactly what we did. We emailed the part and we produced the following week,
And that was denied.
the 7th.
I'm sorry. What I said was that was denied by the court, your request for the additional week.
That's exactly right. Big picture, this is a breach of contract case against Bays for failure to pay links for its services. Twice, the plaintiff attempted to bring in additional entities and individuals on fraud causes of action, and twice they were dismissed. The case should be decided on the merits. There are personal jurisdiction issues, and at least one of the entities, the judgment, if levied, is sustained. There are meritorious defenses regarding the fraud claims. The court has already dismissed them twice. We think it would do so again, but the issue should be decided on the merits. Thank you.
Good afternoon, Your Honors. Samantha Milrod for the respondent plaintiff, Lynx Capital Partners of New Jersey, LLC. Sorry.
Counsel, how do you respond to what your adversary just said, that the court basically invited them to ask for an additional week if they needed it, they asked for the week, then it's denied, and they produce within the week?
If that were the only issue, I would respond, maybe the judge did give them a week, but he didn't. He denied the request. But it doesn't start with that one request. The problem is that there were multiple court orders. In fact, the June 23, first of all, plaintiff had to file over 13 months, one motion to compel, which prompted the court's June 23 order. The June 23 order, contrary to what counsel for the appellants just suggested to this court, is a complete misrepresentation, because the June 23 order was not just directing compliance by defendant Bays, but specifically required compliance by the individual defendants, Gerasi, Sanzone, and Griffinetti, to produce their documents within 45 days as well. After the after the June 23 order was entered by the court compelling compliance with plaintiff's document requests and the the subpoena ducis tecum that was properly served on the individual defendants. Initially, documents were produced as a document dump by the defendant Bays, but the first document production, which was the document dump, was wholly deficient. Plaintiffs then served a deficiency letter. The court met with the parties on at least 3 occasions where the court directed the individual defendants, the corporate defendants, and defendant Bays to comply with the plaintiff's requests and to fix the deficiencies that were outlined. From the beginning, defendants did not produce tax returns, did not produce documents evidencing loans.
Was your adversary's response on July 7th, did that fix the deficiencies?
Absolutely not, Your Honors. To this day, 13, even after defendants said that they completed their production, the defendants never searched the databases for any other corporate defendant. There's 9, I believe 9 corporate defendants for any other than one. They never searched the cell phones for the individual defendants when we know that those defendants communicated via text and produced text messages in our own production showing that they conversed and communicated via text messages. Not one tax return was produced. Not one document evidencing loans was produced. The court outlined all of this in its April 11, 2022 order and said there was willful, contumacious, and deliberate conduct by the defendants to thwart the plaintiff's discovery. And in that April 11 order, the court specifically made a finding that defendants engaged in a pattern of willful and contumacious conduct, continually flouting court orders for a significant period of time following admonitions from the court. It was not like the court said, okay, you didn't produce, I'm going to strike your answers. The court gave them opportunity after opportunity after opportunity, at least 5 different opportunities. And at the last time, when it entered its November 23 order, it said to the defendants, either fix the deficiencies and produce these documents, tax returns, loan documents, bank statements, which would evidence the transfers, the fraudulent conveyances that we do have evidence to support. And said, if you do not produce these documents, I am going to strike the defendant's answers. Defendants had every chance and opportunity to produce the documents and just chose not to.
Why strike the answer of parties that have not even joined issue? They have not even answered the complaint.
Your Honor, the lower court spoke to that. And they said it doesn't matter if issue was joined because the individual defendants and the corporate defendants were all subjects of subpoenas, were all subject of the court's November 23 order at the very least, and were subject to the court's June 23 order. All of them argued in response to the October 4 order to show cause and the renewed motion for sanctions. They all had an opportunity to be heard. They received and accepted service of the second amended complaint. So the fact that issue wasn't actually joined is irrelevant. They were all subject to the court's
Just turn
orders.
your attention. How did you establish jurisdiction over Hockeytown?
Yes, we established jurisdiction over Hockeytown via 302A2 and A3 because Hockeytown, as either a transferor or recipient of the fraudulent conveyances, although they're a New Jersey corporation, law in New York, and it's outlined in our brief, specifically holds that as either a recipient of those funds, a transferee of those funds, or as a conspirator to any conspiracy to fraudulently convey those
Did they do anything in New York?
When you say, did they do anything in New York? Well, the funds were transferred from New York. But as far as they're a New Jersey corporation, whether we never...
Without a New York presence, right?
I don't know if they have a New York presence, to be honest, Your Honor. But they've claimed that they don't, but that doesn't mean that they don't do business in interstate commerce, and it doesn't mean there's specific case law that says personal jurisdiction is appropriate even over a non-domiciliary, who specifically, there's case law specifically as to a New Jersey corporation who received funds from New York, that was sufficient to provide jurisdiction under 302A2 or A3.
Thank you.
Thank you.
I'll be brief. Like 3 quick points. Hockeytown is not New York, has no ties to New York, has no nexus to New York, and there were no transfers made to Hockeytown. Second, with respect to the June 23rd, 2021 order, it did not apply to the entities and individuals. And how do we know that? Because it says, ordered that the defendant, singular, make its production. The only defendant at the time was Bays. And lastly, with respect to the representation that our clients did not search their records, they provided affidavits of diligent search that specifically state, I searched for records and documents and email communications electronically stored on servers maintained by Global Relay. I searched my personal files located in my home on my personal computer. I reviewed my personal financial records and banking records, et cetera. So, thank you.
Thank you. Talking Capital versus Omanoff.
Good afternoon. May it please the court. Brian Jacobs for defendant appellants The Omanoff defendants, I represent them on appeal. I did not represent them below until after the summary judgment motion practice that we'll discuss here today. Applying de novo review, this court should reverse the erroneous decision granting partial summary judgment, finding the Omanoff defendants, my clients, liable to the Talking Capital plaintiffs for breach of fiduciary duty and other claims, and remand for a full jury trial on the merits instead of just the damages trial that the lower court intends to hold. In this case,
The only issue you're arguing on appeal is the unclean hands. So let's focus on that.
yes, Your Honor.
There are two aspects that are required for unclean hands to apply, but I'm going to focus on the second one, which there has to be some relationship between the claim that's being pursued and the bad acts that were done by the person with the unclean hands. So here, the claim that's being pursued is diversion of a corporate opportunity by the Omanoff defendants. How does that relate back to any alleged wrongdoing by the individual who has nothing to do with the Omanoff defendants?
Well, in multiple ways, Your Honor. The claim, and you're correct, the claim must have an immediate and necessary relationship to the inequitable conduct. Here, one category of inequitable conduct are misrepresentations that Bradley Reifler, who is the effective owner of the Talking Capital plaintiffs, made to the Omanoff defendants to induce them to form Talking Capital in the first place. Those misrepresentations are what gave rise to the fiduciary duties that the Talking Capital
Is that what they mean by a direct relationship? That sounds, even the way you're describing it, very attenuated.
Your Honor.
To me. I'm reading direct relationship, that it has to be a relationship between the claim you're pursuing in the action, which is usurpation of a corporate opportunity, which clearly was something that was done by the Omanoff and not by Reifert. And you're talking about maybe what originally created the situation for this to occur, but I don't understand how that's a direct relationship.
Your Honor, this is precisely what happened in the McKenna case we cite. There, the court said that misrepresentations that led to the forming of the entity that gave rise to the fiduciary duties, the conversion of corporate opportunity, it's really a claim for breach of fiduciary duty. That's the claim being pursued. And in the McKenna case, the court wrote that the wrongdoing, the inequitable misrepresentations had an immediate and necessary relation to the claims under which relief is sought by the plaintiffs, because the misrepresentations had an immediate necessary relationship to the formation of the LLCs and barred the plaintiffs from enforcing the fiduciary duties that attached in part because of the misrepresentations. We cite that McKenna case throughout our briefs, and the idea that was a case that, like this one, involved misappropriation of a corporate opportunity as the reason why fiduciary duty was breached. It is on all fours here where misrepresentations are made that lead to fiduciary duties arising, the formation of an entity. Those under McKenna, which is a Delaware case law on point, necessarily bear an immediate and necessary relationship to an effort to enforce those fiduciary duties down the road. In addition, those...
Let's go back to the other half of the requirement for unclean hands, which is that it has to be the suitor who has the unclean hands. Why isn't the suitor here Talking Capital, and in particular Talking Capital as existed in 2015? How is that the same as Reifert, who was just one of three, had one of the three vehicles that was a partner in Talking Capital?
Your Honor, as of today, Talking Capital is effectively Reifler. He's the only individual behind Reifler.
No, but we're talking about the unclean hands when the usurpation took place. I mean, we're looking at it at 2015 when the alleged breach of fiduciary duty occurred. At that point, Omanoff was still part of Talking Capital, and that's why it was an alleged breach of fiduciary duty, because it was still an entity. So it wasn't just Reifert. So even if Reifert had unclean hands, he's just 1/3. How does that bring in the doctrine of unclean hands?
Your Honor, it's under the Bangor-Punta doctrine in the Supreme Court, which we cite in our briefs. Reifler assumed control of the Talking Capital plaintiffs a couple years ago as a result of settling out with defendants in this litigation. So he at that point began bringing this case directly in the name of Talking Capital. There was an amendment to the caption at the point he assumed control, and he began bringing this case through the Talking Capital plaintiffs after he got control. What Bangor Punta says is that when the owners of a company assume control and then try to do something in the company's name that they couldn't have done individually, and Reifler couldn't have done this individually, Forefront couldn't have done it, the lower court seems to even acknowledge they have unclean hands. What Bangor Punta says is they can't do it through a company if they would be barred from doing it themselves. And so here, the equitable doctrine of unclean hands clearly applies to bar Reifler from doing through Talking Capital what he would not have been allowed to do himself. And Talking Capital, he only began using it to bring this case recently, at least recently within the scope of this litigation, when he assumed control of the entities from the settling co-defendants. It's on all fours on this point with the Bangor Punta doctrine that we cite. Just one additional point on Your Honor's initial immediate and necessary relationship issue. Not only were there misrepresentations that gave rise to the fiduciary duties, but Reifler used Talking Capital while he was a manager of the entity to commit numerous frauds. He made it an instrumentality of his frauds.
That's not what's being sued upon here.
There are cases saying that where that is what happens, that party is stopped from bringing the claim, like the Healy case that we cite and the Ross case that we cite on page 42 of our brief. His fraud, using the entity and entwining it in his frauds, prevents him, under the equitable doctrine of unclean hands, from maintaining this suit. Whether or not the Omanoff defendants usurped a corporate opportunity or not, and we maintain they did not, but does not matter. The unclean hands doctrine applies regardless of the merit. It is meant to protect the courts from being misused by a party like the Talking Capital plaintiffs and Bradley Reifler from doing something inequitable, from benefiting where they behaved inequitably. I'm happy to reserve the rest of my time for rebuttal.
Thank you.
Good afternoon, Your Honors. David Bowles, may it please the court, here for respondents. Your Honors, the party that's asking the court to bless an inequitable scheme is Mr. Omanoff and the other defendants. The court is absolutely right to go straight to the immediate and necessary connection issue, but an even greater overriding doctrine is here. That is the doctrine of public policy. We cite the court to Nakahara, and Nakahara says the greatest limitation on the doctrine of unclean hands in Delaware is public policy. Here, clearly, Delaware's public policy is to punish people who breach their fiduciary duties. It would be repugnant to the policy of Delaware to allow Mr. Omanoff to walk off, admittedly, with tens of millions of dollars. My opponent just said.
We're talking about unclean hands.
Yes,
so
Your Honor.
Unclean hands is you're looking at the conduct of the plaintiff. We're not talking about the conduct of the Omanoff defendants here, because the issue, an unclean hand, is not whether the Omanoff defendants did something wrong, it's whether the plaintiff has the right to pursue the claim, whether or not defendant did something wrong. So I'm not sure why you're focusing on defendant getting away with the wrong, because the doctrine of unclean hand really looks to the plaintiff's behavior and the plaintiff's actions.
I understand, Your Honor, but also would encourage the court to look back at Nakahara and Lynch, and the trial court cited a case of Hart versus Scaglia, and the Triton construction case that we cite too, that says what the public policy of Delaware is to punish these type of people. You can't let Mr. Omanoff get away with it. The trial court said that explicitly. Yes, Your Honor.
All of that, is there still an issue presented by the fact that doesn't Omanoff testify in terms of misappropriation of corporate opportunity that DLI would no longer fund any deals with Talking Capital because of Reifler and Forefront? And Talking Capital basically did not even have the ability to stay in business, so that you wouldn't have been able to take advantage of anything. Isn't there an issue of fact about that?
I don't think so, Your Honor, because what Mr. Omanoff also testifies to is he's the one that told DLI that Reifler was acting inappropriately. He's the one who calls DLI to breach the non-compete with the company. I don't think there's an issue of fact there, Your Honor. And again, Your Honor.
It was improper for him to inform DLI that the corporation, that an agent of the corporation was acting in a criminal manner?
It was improper for him to encourage DLI to breach its contract with Talking Capital. He should have stood by that contract, Your Honor, and enforced it, in fact, instead of encouraging DLI to go off and fund his alternative company, which is clearly what he did. But I would like to return to Justice Kearns, if I could, point about immediate and necessary connection. There's absolutely no immediate and necessary connection here. I think the trial
What
court
about the McKenna
recognized...
case, which does seem to have some similarities to this case? How are you distinguishing that case?
McKenna case, Your Honor? The McKenna case is different primarily because my opponent doesn't mention that the McKennas were the plaintiffs there. That's the big difference. That was a direct case. The McKennas were on the caption. They were the ones who sued. It is much easier to forge an immediate and necessary connection between the parties that actually have the unclean hands and the claim at issue. And here, as the court I think has already recognized, the claims at issue here are misappropriation of corporate opportunity. They are starting a competing company. Fine. Everything they allege as against Reifler has nothing to do with that. First of all, these two corporate levels are removed, as the court has said. He was the owner of a company that owned 1/3 of a company at the time. How can you claim that Talking Capital had unclean hands when it was equally managed by Mr. Omanoff and Mr. Proto at the time? You simply can't. And the trial court recognized that, and that's why McKenna is easily distinguished in this case, Your Honor. We would also argue, Your Honor, that even though this is a technical point, that they presented no admissible evidence. CPLL 3212 requires an affidavit in response in a summary judgment motion. They presented a federal-style declaration under 28 U.S.C. 1746. We cite the court to its own case of Disco Vision from 2010, in which the court admonished counsel that you can't use federal-style declarations. We cite the court to the Zhu case, in which the Supreme Court held that those are not admissible here. And I'll cite today the court to comment 5 to CPLR 2106, which it kind of amusingly says, the advisory committees keep telling the legislature it would be great if we could use these declarations in state court, but you can't. They submitted a declaration. That's the only way they shepherded in evidence. That is sufficient reason to affirm the Supreme Court in this matter. And the declaration was notarized in Los Angeles, and it lacks a 2309C certificate of conformity. I know there's been back and forth about this, but we cite the court to its own case of Attilo from just 3 years ago, in which the court declined to consider a affidavit without a certificate of conformity. They cite the court to the Matt Post case, but what Matt Post says is that this is a correctable defect. We objected to this in February of 2022. They had until August at oral argument to correct it. They never did. And we think that they simply didn't submit any admissible evidence.
Here's a question, going back to your public policy argument.
Yes, Your Honor.
What about the public policy that there's no dispute that Reifler did engage in a lot of wrongdoing and was actually convicted for his wrongdoing? Why should he be allowed, as the one who primarily controls the entity now, to bring this lawsuit against Omanoff?
Because
Doesn't that violate public policy somehow?
No, Your Honor, because his wrongdoing, which got him convicted of something, it has to do with another company entirely. My opponents have always tried to conflate these two, but that's the issue, if you'll recall, that Justice Schechter said was a sideshow that won't be tried here. That's another case. Didn't have anything to do with this case, and it was Reifler's wrongdoing. I'm sorry?
So no direct relationship between...
The common thread between that doctrine and the estoppel doctrine that they cite to all has to do with whether or not the plaintiff had to do with the wrongdoing at issue, with the claims at issue. For example, if Mr. Reifler had been involved as a member and manager of Voight Guardian, then sure, their doctrines would apply. There would be an immediate and direct connection between the wrongdoing there. I could see that. But that's not the case. Reifler didn't know about it. Forefront Partners didn't know about it. Talking Capital didn't know about it. That's kind of the point. This was all done in secret as a scheme. The court should not lend its blessing to that scheme. Happy to answer any questions that the court might have.
Thank you.
Thank you, Your Honors.
Your Honor, I'll briefly just respond to some of Mr. Bowles' points. First, McKenna is a direct case. It's also a derivative case, and as we pointed out in both our papers and in the main argument, that doesn't make a difference. You can't do directly, derivatively, or otherwise things you couldn't do yourself under the case law we cite. Second, Mr. Bowles talks about Mr. Omanoff walking off with money. That's not what happened here. There's litigation in California over that business opportunity that was not a real opportunity at all, and Mr. Reifler's effort here is really to jump the line of the creditors in that case. This is beyond the scope of the appeal, but just to be clear, he's not walking off with anything. There is a relationship between the crime of which Mr. Reifler was convicted and the issues here. He was there, made a manager of a reinsurance trust, and was supposed to invest the assets in an appropriate way. And as part of his effort to steal those assets, he submitted documents securing them with Talking Capital's name on them, with my client's forged signature on them. There is a relationship there. As it was pointed out, there are extensive fact issues. Thank you, Your Honor.
Thank you. And our last case, People versus Divine Fredericks.
Good afternoon, Your Honors. May it please the court. Marika Meese for Mr. Fredericks. This court should reverse because the lower court summarily denied Mr. Fredericks' request for a new lawyer without any inquiry, and as well, his lawyer took a position in opposition to that motion. Here, Mr. Fredericks had written both a letter and a pro se motion to the court detailing that he and his lawyer were not getting along and that he didn't feel satisfied with his representation. But no court made any inquiry whatsoever in regards to that motion. Instead, the court summarily denied it. The court had before it enough to make a minimal inquiry because there was evidence of a breakdown in the attorney-client relationship. And the minimal inquiry is a threshold requirement that has to be made, even if, upon inquiry, a court could determine that the motion ultimately did not have merit or should be denied. But without any inquiry, this case is like this court's recent decision in Resherup, where again, the request for new counsel was given no...
What were the defendant's specific complaints why Zismore was no longer a good attorney for him?
I'm so sorry, I didn't catch the end of that.
What were defendant's specific complaints as to why Zismore was no longer a good attorney for him?
He said a variety of things in his papers, but that's precisely why an inquiry by the court was warranted, because the court needed to do a further probing of what the issues were. But he did establish that he and his lawyer weren't discussing things, that he didn't feel like his lawyer was preparing the case for trial with him, and that his lawyer was aware that he didn't want him on the case anymore. So I think that alone showed a breakdown in the attorney-client relationship and or the communications between the lawyer and client. And those are precisely the type of issues that warrant replacement of counsel. So here the court had enough, based on the minimal amount it had, to do a further inquiry. And the minimal inquiry is, as I said, is a threshold requirement. It can't be foregone just because the court thinks that ultimately this request might not have merit. And here as well, instead of making an inquiry, the court simply asked whether counsel wanted to join or adopt the motion, and the lawyer then took a position adverse to his client's request. Instead of saying that he did not wish to join, without any inquiry from the court as to an explanation of what was going on, the lawyer then elaborated on a bunch of the details of his interactions with his client and suggested that the request had no merit. So in so doing, he took a position adverse to his client, and it's
Didn't
not
the Court of Appeals say that that's okay in People versus Washington, that it's that an issue, a conflict of interest is not created merely by the outlining of efforts on the client's behalf?
That is correct, Your Honor, but in Washington, that's where the court specifically asked counsel, what do you have to say about this motion? The court didn't do so here. The counsel on his own decided to elaborate on the lack of merit of the motion and to detail how he was communicating.
This case turns on the fact that the court didn't specifically ask counsel to respond?
I believe that's essential to the holding in Washington, was that there had been a back and forth, and the court specifically inquired of counsel, what do you have to say about your client's claims? That didn't happen here. So absent that prompting or request for that kind of information, for counsel unsolicitedly to give the information about the representation and try to defend his conduct was not permitted and a violation of my client's right to counsel at a critical stage. I'd like to turn briefly to the issue of the 440 motion. My client had filed a pro se 440 motion that the court summarily denied. In so doing, the court essentially adopted the reasoning of the people in their opposition, but they had made factual and legal errors that the court didn't really look into. My client had been sentenced to 45 to life, and he was only 29 years old. This was a serious matter, and his claims were based on things outside of the record. He submitted non-record materials to support his claims. As well, the court had an obligation to liberally construe those claims in their best light and to give them the legal strength that they had. The court easily could have and should have appointed a lawyer to that motion, and the lawyer could have supplemented it because, as we raised in point 2 of our brief, there were numerous record-based claims of ineffective assistance of counsel that a lawyer could have raised, and there were also other non-record bases that could have supplemented that motion. It was also improper for the court to have blamed Mr. Fredericks for not getting an affidavit or an affirmation from his lawyer. The court was well aware of the discord between Mr. Fredericks and his lawyer. At sentencing, my client refused to come out and be represented by that lawyer, and he had filed a grievance, all of which the court was aware. I see that my time's up. Thank you.
Good afternoon. I apologize. ADA Nicole Neckles for the Office of Darcel D. Clark. May it please the court. The trial court properly exercises discretion in denying defendant's request for a new counsel. Counsel suggests that the minimal inquiry is a threshold. It is not. The threshold is defendant has to first make specific allegations of serious complaints in order to get to the initial inquiry. Here, defendant did not do that. Defendant had the opportunity to do that. Defendant wrote a letter to the court, and in that, he had all the time and all the space to have expressed the dispute he had with counsel. Defendant made 3 allegations.
Defendant expressed, wouldn't it be a reasonable view to interpret it as a breakdown in communication with his attorney?
No, it's not, Your Honor. What defendant said was that counsel was not, a general complaint that counsel was not working in his best interests. He then said that counsel did not come and make a visit with him while incarcerated. And the third was that counsel disrespected his wife and hung up on him. That certainly does not rise to a serious complaint or show that there was a breakdown in communication, that counsel failed to explore legal or factual issues, things that would bring counsel's performance into question. And the court nevertheless explored the issue with counsel and defendant. The court brought it to the counsel's attention that this motion had been filed and asked counsel if he wished to adopt it. Counsel expressed his understanding of the conflict and stated that defendant just was not happy with his assessment of the case. Again, that does not go to counsel's performance or his ability to represent defendant. Defendant was present when counsel made this representation. Defendant did not dispute counsel's representation about the breakdown. Defendant cannot sit silently, and by not disputing it, he essentially said to the court, that is the conflict, that I just don't agree with what my attorney is saying. And that does not get defendant new counsel. And so defendant, Your Honor, cannot sit quiet when the issue that he has raised to the court, and the court is discussing it, and the court is presenting it to counsel, does not elaborate and provide any other detail. He cannot then be permitted to come before this court and say, I didn't have an opportunity to speak. He did have an opportunity to speak. All he said is, I want new counsel. What he said did not raise a specific, serious complaint that warranted further inquiry. And the court was therefore appropriately denied the motion. Furthermore, counsel's general statement that his client was not happy with his assessment of the case, that is not ineffective assistance of counsel. Counsel did not make any factual representation about the factual or legal basis of counsel's claim, of defendant's claim. He did not really address, while he said he gave his assessment of the case, he did not say what his assessment was. He did not say what he thought of the prosecution's case, the strength of it, the weakness of it. He kept it very general. Nothing about that rises to ineffective assistance. The court has very clearly said that counsel can address claims of ineffective assistance. What matters is not whether counsel volunteered the information. What matters is what counsel said and what position counsel took. And here, counsel very clearly did not overstep the bounds when he just stated what his position is as to his representation. Finally, I would just ask this court to affirm defendant's sentence. While defendant's sentence is lengthy, defendant here was a persistent violent felon. The evidence showed there was overwhelming evidence of defendant's guilt. The video evidence here showed the callous nature of defendant's conduct, where defendant shot his friend of 10 years who viewed him as family in the back of the head. Defendant then attempted to shoot the sole witness, the driver. Video evidence corroborates everything. We can see defendant exit the car. We see defendant stand and attempt to shoot the witness. In a moment of clarity, the witness was able to drive away. We then see defendant calmly place that gun in his waistband, cross the street, and stroll down the walkway. But for that video, nobody seeing defendant walk down that walkway would have thought he had just shot his friend in the back of the head and attempted to kill another individual. Defendant's conduct, his lack of remorse, and his history justifies the sentence that was imposed. And we would ask that this court affirm. Thank you.
Thank you.
On the issue of the request for a new lawyer, it's not true that Mr. Fredericks had an opportunity to address the court because he was never once asked to do so. And what he put in his paper and his letters and his motion was enough for the court to infer a breakdown in the relationship. He said, my lawyer is not talking to me. He said, my lawyer is not communicating with me about preparing for trial. Those are important issues in a person who's facing 65 to life or beyond. And the court should have done that minimal inquiry. And I disagree that it's not a threshold requirement because in Sides and Linares, they clearly state that it is. It's not just that the defendant has to show enough initially. These cases say that the court has the obligation to do that inquiry and to see what else there is to say. And as well, counsel's response wasn't just saying, oh, here's what I did. He essentially said, my client is just a complainer. I've done everything. And in so doing, he took an impermissible position adverse to his client.
Complaints were more in the nature of that he hasn't come to see me and talk to me. And the response is, well, I've been working very diligently for him.
Those were some of the complaints, but those weren't the extent of them because we also were missing in the record the pro se motion that doesn't appear and we couldn't find from the court file. We have at least the letters that detailed those kind of complaints, but the essence of those complaints were not just that he didn't come to see me. It's like, he's not communicating with me. This is a very serious case. We're going to trial. I want to go to trial. I've asked him to investigate things. I don't want him on this case. And that warranted the minimal inquiry that the Court of Appeals and this court has repeatedly affirmed needs to be done in that kind of circumstance. In terms of the sentence, Your Honors, the court had the discretion to give concurrent terms to the attempted murder and the murder. And in this case, my client had been offered a 20-year flat sentence before trial. Counsel, again, did zero advocacy at sentencing. So this is a case where a reduction of sentence is warranted. And I disagree that the videos clearly show anything because you can't see facial features. All you can see is general. And the video that supposedly is a person walking by after, we know that the timestamp on the video that counsel didn't contest was 45 minutes off. So that wouldn't have even been after the alleged incidents, according to the complainant.
Thank you.
Thank you. Take care.